Welcome to Restaurant Deal Making Exposed, the only show that equips you with everything you need to know about restaurant transactions. In this show, we tell you all about how to make the sale or purchase of your restaurant not just possible, but successful. Now here are your hosts, ex-restaurateurs and seasoned brokers, Patrick Toda and Andy Mirabel.
All right, here we are, everybody, with episode 11, Attorney at the Table with Roberta Economidis. Hopefully I got that right for everyone. Roberta is a founding partner at Georgopolis and Economidis Law Group, a boutique law firm based in San Francisco, California. She specializes in corporate and business law with a particular focus on the hospitality industry. Her clients include restaurants, nightclubs, brewers, and other hospitality-related businesses, whom she assists with corporate structure, lease negotiations, private equity offerings, licensing, and permitting issues. When opening a restaurant, it's easy to get caught up in the excitement and overlook the importance of having an attorney at your side. However, legal representation is crucial to protect your interests throughout the process. An experienced and specialized attorney can expertly guide you through the complexities of purchase agreements, lease negotiations, intellectual property matters, and regulatory compliance, ensuring your restaurant starts off on solid ground. This is something that I can speak from experience on. When I went into business, I signed a lease with the largest landlord in San Francisco, Boston Properties, and I was so eager to get started, and I wish I would have had Roberta on my side. Thank you for joining us today.
Thank you for having me.
Yeah, thank you, Roberta. I want to just kind of segue a little bit off a couple of these things. I felt a little green when I came into San Francisco and opening, branching off from my past job with a larger restaurant group and opening my own restaurant in San Francisco. And I felt like, the little man in the deal here. I had a very wealthy, very powerful landlord who owned a lot of property, was very versed in leases and what he wants out of the leases. I won't name his name, but I didn't make the smart choice of seeking representation at that juncture in my career. And I really think it would have helped me a lot. So Patrick and I have crossed paths with Roberta multiple times for multiple transactions. We've worked together on some, and her reputation precedes her because of her focus in what she does. So Roberta, I really, like I said earlier when we were talking, we hold you in a very high regard. Of course, we shake in our boots a little bit when you're on the other side of the deal. I will be honest there.
Thank you for that.
Sure. I think that's a good thing, right? So really, Roberta, I want to get a little background on you. It's so nice to have you here again. And I learned, you started your career as a deputy district attorney in Santa Clara County. Is that right?
Correct.
Okay. How do you get from there to here?
Well, it was a path that I never thought I was going to take. I was a deputy DA for 5 years, and then I received an offer to work for the state treasurer of California, and I took it. And it was great. I was an appointee of his. And at some point, I realized that I missed the practice of law, and I had always thought about going out on my own. So I met with my now business partner, Zach Georgopolis. We talked about me going solo and being on my own, and I did that. And for me, the natural progression was to do civil litigation and I did some criminal defense as well. But Zach and I were friends, and Zach said, "Hey, I have some overflow work. Do you want to work with me?" And we started working together. And I guess I can tell this story. But so one night, Zach and I went out after a hard day's work. We went to Belden Lane. We had a little too much wine, and we talked about forming a law firm. And the next morning, Zach called me and he said, "Hey, if you weren't serious about that whole law firm thing, that's okay." And I said, "Oh, well, I don't know if you were serious." And that's how it organically formed. And, I laughed because it was a little too much wine, but it was a great decision for us.
Isn't that how we get to some of the best memories, decisions, and so on?
Yes.
I guess I could say the worst also, but
Good things always happen at Belden Lane, I tell you.
Yes.
Yes, it was Belden Lane. I will always be grateful to you for that. So Cafe Tiramisu, just to put a plug in.
Nice. Okay. Got it. I was a B44 guy. So how do you know Zach? You had a relationship or friendship prior to working together, obviously.
We were both are members of the Hellenic Law Society. We were both on the board actually in the 90s. And in the late 90s, I was president of the board of the Hellenic Law Society, and Zach was my vice president. And so
it seems like a match made in heaven then, professionally. That's great.
Our paths just kind of kept converging and brought us to this place.
Now, this overflow work that Zoc came to you and said, hey, can you help me with this stuff? And then you guys drank a bunch of wine and formed a law firm. Just like that. That's exactly how it went. Can you tell me then, what was the overflow work, or was he already working with people in the hospitality industry, restaurants, things like this?
Yes. Zoc had specialized in the hospitality industry, for quite some time. And Zoc actually, when we look at a lot of the preferred offerings that we do now and whatnot, Zoc did a lot of this stuff from scratch in the 90s. And it's really incredible when I look back at what he did. And so, yes, he said, hey, look, he said, I know this isn't exactly what you do, but I think you would be good at it. And he brought me in on, can you negotiate this liquor license? Can you, negotiate, it started kind of small. Can you negotiate these LOIs? So, I started getting my feet wet in that area. And so that's pretty much how it started. I will tell you, I think I mentioned that when I went solo, I went to Zoc. I went to several attorneys to talk to them about going out on your own. And when I went to Zoc, he said, sure. He said, let's have dinner and talk about it. And we had dinner and he explained to me his practice. And I remember him talking about all the restaurants that he represented. And I just thought it was the coolest thing. And I never thought I'd be doing it. But I was so impressed with, all these restaurant clients that he had.
This is where, Patrick and I, I'm sure, can agree on this, and our listeners and anybody out there. It's neat to be in this niche. I love what I do. We're backgrounds in restaurants and ownership and stuff, and we stay in our lane. And so this makes it better for our clients. And it's so interesting for us to know that there's attorneys out there like you and Zoc that focus on this wholeheartedly. So, that should give them a real sense of comfort in dealing with you or in these situations. How do people reach? Where can they find you if they need help specifically with their leases, purchases, anything else like that?
Most people just reach out to us either from our website or call our office. We're kind of old school that way, in that people just can go through the website or give us a call. I still get calls saying, I got your number and getting an inquiry. And, we're always happy to talk to people. And if we don't feel like we're a fit for what they need, I'm also always happy to give referrals out to other people, even other lawyers. There are a lot of great lawyers out there, and I enjoy working with them.
Well, I bet your business is heavily referral based, heading, people referring to you, given what you do and you and Zoc do. So kudos to finding that niche and getting in it and staying in it. You're great at what you do. So, we often encounter clients who bring, in different kinds of attorneys that don't necessarily maybe have not dealt with leases or restaurant purchases, things like that in their past or, historically. So sometimes that can pose challenges because we feel like there's a hindrance to get to the finish line and get to the escrow close and so on. So having someone like you or Zoc that specifically deals with this often does streamline these things and helps the, deal get done more efficiently. So we appreciate that as agents. Can you explain the significance of working with a business attorney who specializes in these transactions and how it can streamline a process or hinder a process if maybe they're not experienced in this area?
I think part of the way that it streamlines the process, or I think part of the benefit, is that you see so many different types of transactions and you see so many things happen, both good and bad, right? And sometimes I feel like a little bit of a broken record when I'm reviewing a lease or doing a deal where I will say to a client, I once had this happen, or I just had that happen. And I think that being in the industry really allows you to have insight as to what's happening to the industry, what some of the pitfalls are that maybe other people don't think about because they don't do it every day.
Mm-hmm. Yeah, absolutely.
Do you actually come into contact with a lot of people on the other side who bring their cousin lawyer or a lawyer that has no business being in a business transaction? Does that happen at all?
Over 20 years, yes, a lot has happened.
You've seen it all.
I hope I've seen it all. Probably not, though. I do see a lot of times people bring in business lawyers or sometimes you have landlord lawyers, right? Who just look at things from a landlord perspective. And I have to say to them, this is why this provision is problematic. And you have to look at it through the lens of a restaurateur. And here's the thing, is that any good attorney who doesn't understand this area will know that, and we can have a conversation about it, right? So I'm always happy when there's a good attorney on the other side, because I think it makes for a better negotiation and, frankly, a better outcome.
Yeah, absolutely. I mean, I think in a very general terms, what Patrick asked for our listeners to kind of hear is, when Patrick and I maybe have a buyer or a seller who wants their residential agent to help them in a restaurant transaction. That poses a lot of challenges, and we have to sometimes pump the brakes on that and say why in a professional way, why that may not be beneficial to the deal. So you just said look through the restaurateur's lenses. Did you serve tables or anything through law school? Or how did you learn to look through these lenses? Is it all through experiential based?
I did not, but I ate out a lot. So I'm also Greek. So of course you have relatives, who, own diners along the way and whatnot. The restaurant world has always been in my life in some fashion, but I did not wait tables or anything along those lines.
Well, we love that you pointed out that you're Greek, and Zach obviously is also correct.
Yes.
Yes. So at the end of the episode, we'll make Patrick say both your last names 5 times fast and go from there. Okay.
I can't wait.
Yeah.
So, Roberta, when you are dealing with client and business transaction, what do you believe the most critical factors are to overcome in a deal, both in terms of a purchase agreement or in a lease? What are the things that you really focus on?
You focus on a lot of things. And I think the first thing that you have to focus on, is this the right deal, right? Is this the right location? Are the assets of value that you're purchasing? It has to be right. The first mistake that people make is when they say to me, I just want to get open. That's a big red flag to me. And I've had some clients with great concepts go into the wrong space. I think the first thing in a business deal, we'll talk about why this space works, why you're purchasing these assets. And then, frankly, I look at the terms. And I think it's really important that people have the option not to necessarily get out of the deal. That's not the word that I want to use, but that they have options. So as they learn about the deal as they go, if they need to, they can get out. We need to have lease contingencies. We need to sometimes have financing contingencies. I look for those kinds of things in an asset purchase agreement, because oftentimes people will come to me with an LOI, and the LOI will say, you're accepting the lease as is, and they've never seen the lease. So I look for flexibility and the reasons why they're going into the space.
Yeah, I can't tell you how many times I get a client who doesn't want to spend the money on an attorney until they know they're going to do the deal. And then they're like, then I'll have them review everything. I'm like, no, you need to have them review everything. You got to spend a little money up front, because by bringing them in at the end, you're going to open up a can of worms by bringing in a good business attorney that you may not want to do. You need to know this stuff up front.
Yeah. It gives me great pleasure to tell people I cannot give legal advice. I love that phrase. You know what I mean? It takes the pressure off of me, but it also allows me to make introductions to folks we trust. We had Jordan Cohen from Brick and Mortar on, a couple months ago, right, Patrick? He's been such a pleasure in so many different aspects of what he focuses on. So I think Patrick and I are lucky to have resources like you and Jordan to.
Absolutely. Yeah, no, Jordan's great.
Yeah. In your experience, I know you've done it all within the restaurant realm here, but do you most often represent buyers and sellers in asset purchase agreements or purchasing a successful business? Do you most often represent lessors, lessees? What makes up the crux of your business?
I mostly represent buyers. I've been fortunate in that the majority of my clients have not had to sell, which is great. So I mostly represent buyers and I mostly represent tenants. I have, of course, represented sellers and landlords, but really we're more on the buyer side and the tenant side.
Got it. This wasn't on my punch list here, but what conflicts do you see when agents such as Patrick and I, who work within this niche, we very often are dual agents? What are some of the red flags in that you see from your perspective?
Well, the dual agent thing can be a little bit tricky. Look, I think it's like anything else. If you have a good agent who's representing both sides and who's going to be fair to both sides and who is not pushing the deal in order to get a commission, I think it's okay. I think it really is dependent on who that particular agent is, because there are agents, and this is part of the reason, that I enjoy working with the two of you. You put your clients first. Right. And there are agents, frankly, who don't, and who will push to get a deal done no matter what, even if it turns out it's not the right deal. So, that's where I think the dual representation can get a little tricky, because if they're pushing for a deal to get done, one, that maybe shouldn't get done, one side is not being properly represented.
Well said. Well said. And thank you for that. I really appreciate it. All right, Patrick, what's next?
Can you explain the difference between an asset sale and a stock sale? And how many times have you done a stock sale in a restaurant transaction?
So an asset sale is when you purchase the assets of a business, and it's a business to business sale. So restaurant LLC, one is selling to ABC LLC, and they're selling their furniture, fixtures, and equipment. They're selling their liquor license. They're selling their lease, all of the assets, everything that the business owns. That is the majority of what we do in this business. With respect to an equity sale, that would be an individual or an entity coming in and actually purchasing the equity of Restaurant One LLC. And you don't see that as much. And part of the reason for that is because, it's a little bit trickier with respect to liability. When you do an asset sale, I always recommend that it goes through an escrow, that creditors are notified. And that way you can't have somebody come back later and say, well, it doesn't matter to me that you bought Restaurant One LLC, you owe me $5,000, and I've seen that happen. So I actually, depending on the transaction, I prefer an asset sale. We have done equity purchases before. And again, it has to be for the right reason.
So in short, with the asset sale, you're saying it's safer for the buyer and seller. There's less things that can come up after the fact, given the escrow that is held.
Correct. But sometimes you want to go in and purchase that equity. Sometimes there are reasons, whether it's an issue with respect to the lease or other reasons that you might want to do it. But by and large, I prefer the asset sale.
I've done one stock sale in my time here.
You used the word buy the equity. Yeah, I know I've got into contract with one and never got to the finish line with it because there was so many different details at play. But you used the word equity. You're also buying their liabilities too, correct?
It depends on how you structure it. Certainly the times that I've structured it on a buyer side, we have disclosures in the agreement. We'll have indemnification provisions so that you're not purchasing their liability, hopefully. But again, I think part of it is it can be a little trickier from a creditor side.
When you're not purchasing that liability and you have these indemnifications in place, or just a indemnification in general, you still have to defend yourself to go through that whole process. So it's not just clean and clear, like you're off the hook. Is that correct?
Correct. Again, that's where I think it's a little easier to say, well, there was a bulk sale escrow and, creditors were noticed, and go after Restaurant One LLC, because I'm ABC LLC. It's a completely different entity, and we're not liable here. I think it's an easier position to be in.
I'm not trying to put anyone on the spot here as far as the California Association of Business Brokers Asset Purchase Agreement, which is a boilerplate. It gets updated and tweaked each year by the attorneys that work with the CAB Association. But Patrick and I use that very often. It's because we believe we understand it the best and so on. Are there certain sections and areas within the CAB Asset Purchase Agreement that irk you, bother you, that you steer clear of, that you repeatedly, red line, cross out, or, red flag for your clients?
I can't say that there's anything that I automatically will cut out. I think, to your point, I think that there's a lot in there that you probably don't need in most of these sales. So that's number one. I don't think a contract should have provisions that aren't relevant in it. So that's number one. Number two, I think that sometimes we need to get a little bit more specific in terms of a deal. So if something is very straightforward, I think those forms completely work. I do think that, you have to check to make sure that everything's in there that you want. But I can't think of a single one where I didn't do an addendum to clarify, whether that was beefing up the representations and warranties or the contingencies. And no disrespect to brokers, but brokers oftentimes, they like to put in, I can't remember if it's section 14, there's like an other.
Yeah, section 6, line M. It's a big section of blank. So let's pack it full, no spaces. Let's put as much information there as possible.
Totally.
I've never done that, Roberta, ever. My nose is growing.
So I think the form is fine. I'm not one of those attorneys that's absolutely opposed to working with it. But if you're doing something that's complicated, I think it can get a little bit confusing, or it doesn't cover all the bases.
Do you think that Andy and myself going through a contract like that and starting to redline things out, are we getting outside of our lane and we're not attorneys? Are we putting ourselves at any kind of liability if we start to change the contract? What do you think about that?
I mean, Patrick, you're asking me to give you legal advice.
Start the clock.
I'm so sorry. That is so true.
Look, if they're deal points, you fill those in all the time, where you will say, here's the deposit, here's the purchase price. I think that you can make suggested changes and then have the client run it by their lawyer.
Makes sense. That's a good, safe way to do it. what is your primary objective when representing a client in a restaurant transaction? I think clearly we know what the role of an attorney is and to represent their client to the best of their ability and protect them. But can you expand a little bit why it's so important in the restaurant world, dealing with landlords, leases, ABC licenses, and so on? What's the primary objective to protect them from?
I think that it is not just protection for today, but it's protection long term, right? As we've seen in COVID, and this was true even prior to COVID, but as we've seen, anything can happen. And I look back at some of my clients who entered into leases, let's say from the 2016, 2019 timeframe, and maybe they weren't great leases. And I remember having discussions with them about their lease. And they said, Roberta, it's a desirable area. It's San Francisco. I can always assign it if I need to. This is, it's going to be easy to get out of. Right. Well, it wasn't. And that's more of an extreme, I think, example. But the truth is that you want a good lease today, but God forbid if something happens 5 years from now, you do want to make sure you have a good assignment clause so that, you can get out. You want to make sure that, in my opinion, that you don't have transfer premiums with landlord where you're not recouping some of your investment.
You're talking about shared consideration clauses, things along these lines?
Yes.
For the people who don't know that, can you kind of understand? Because I know Patrick and I will get a lease. I guarantee you he does it and I do it. I go directly to that section first and foremost. And I say, and then I go back to my client and I say, I've reviewed your lease. There's obviously some positives here, but I said I need to address the elephant in the room is that your lease looks very hard and restrictive to assign, or maybe it's unassignable. So we need to get some conversation going with the landlord to assure that they're going to be able to assign this or transfer it without leaving you empty-handed.
And I'm happy to talk about the transfer premium that I just mentioned, but I think there's two things with that, if I may. I think there's the assignment provision, and then I think there's the guarantee. Those are kind of the big ones. Because again, what you're looking at is, if something bad happens, how do I get out of this? And I said this to a landlord on Monday. I said, nobody's trying to get out of the lease and not give you what you're due. But, this particular landlord wanted the client on the hook, for 10 years, a difficult assignment clause. And, I just said, should things go right, this is not going to be good. So with that, the transfer premium that I was mentioning is often we go back to the sale of assets. So let's say that with a liquor license, a lease, and a furniture, fixtures, and equipment, you could sell everything for $300,000. And things aren't going well, or maybe you decided this is not for you, whatever the case may be. If there's a transfer premium, depending on how that transfer premium is written, a landlord could take 50% of that $300,000. I've seen 100%.
Yeah, I have a terrible example of this that killed a deal before the pandemic. I saw the clause up front. I told them about it. They said it's not going to be a problem. The landlord's not going to do that. It's the first and last time I ever took that as, what was going to actually happen. And I had a client come purchase and we're going through the whole thing. The landlord held strong to a 75% consideration clause. And my client, the seller, said, okay, well, we'll do it, but we have to take out the purchase price of the Type 47 liquor license, which they moved there and worked very hard to get it there. So they said, as long as they take that out and they net that out, and then, we'll give them the difference. And the landlord would not agree to do that. And so that deal was killed. And 6 months later, I believe the pandemic happened and they moved the license out of there and the landlord got nothing. So I can't tell you enough. That clause is one of the worst clauses I've ever seen in a lease.
And I think there are so many things that I think another thing, because you mentioned the liquor license, landlords who are saying, I get a right of first refusal, to purchase a liquor license. That's going to impede somebody's ability to sell, to move. So when you talk about, when you're looking at a deal, what you want to think about, I tell my clients, and this is true also when we talk about offering documents and investors and corporate structure, we're looking at this today, but I'm also looking at this 5-10 years from now. And I can't predict the future, and I can't stop everything bad from happening or necessarily mitigate everything bad that could happen, but let's try. And I will say this, I think that there are clients who will make a decision to go into a lease where there's a bad transfer premium or there's an onerous guarantee. From my vantage point, as long as they are making a very informed business decision, it's ultimately their business decision. But my job is to point out to them, here's all the ways that this could go wrong for you.
If a personal guarantee is in place for the right deal, are you okay with your client having that personal guarantee run through the full term that they're, even if they assign the lease to someone or sell the business, if they're still on as a backup guarantor or a guarantor till the end of their term, even if someone else is in place, are you generally okay with that? You threw out a longer number, like 10 years and earlier.
No, I'm not. And I think it also depends on what's happening in the marketplace, right? Because as we all know, these things are fluid with respect to some of these deal points. I encourage every client to do a limited guarantee. So if the landlord wants a guarantee throughout a term, I like to do a rolling guarantee. Let's say a cap of 1 year throughout the term. You can get really creative with these, right? It's a full guarantee for the first 3 years, but after that 3-year mark, it becomes a rolling guarantee. And my issue with keeping a tenant on in an assignment is you don't have control over that person's business. And most of those leases will say the landlord can go after either one. So if you're the guarantor and you're the homeowner and the person that you assigned it to doesn't own anything, who's the landlord going to go after? Maybe both of you, but
Does the landlord have to, by the terms of most leases, go after the tenant that's in place that is in, quote unquote, the lead guarantor? Or can it be rather arbitrary and go after both if there's a default?
Is there an order, I think is what Andy's asking. Yeah.
Yeah, I mean, you're going to have to get damages, right? And prove up your damages as a landlord. That's how you go after the guarantor. So presumably there's going to be a lawsuit against the tenant, but then, once damages are assessed, then the guarantor is going to be on the hook for those.
Does the landlord do they have to go and try and get a tenant in that location? Do they have a right to go and try and lease it as quickly as possible to limit the personal guarantee?
Technically, they have a duty to mitigate, right? Not technically. I mean, they do have a duty to mitigate. The problem is, if you're in an environment, like we are in now, what is, mitigating and working towards mitigation can be difficult. I had a lease termination where the rent was over market and landlord wanted that same market rent and he wasn't going to get it. So he couldn't get a tenant in there because he was asking too much, and we ended up settling that matter, thank God. But, so yes, there is a duty to mitigate, but I think that it can be a little bit complicated in terms of the actual application.
Yeah, this is such an interesting subject, and I appreciate it because this is so vital. A lot of restaurateurs go in heart first to a lot of these locations, like, this is perfect, I'm going to thrive here. But if you glaze over these, especially these lease terms, like, this could really bite you in the rear end, so many years later. And that's what Roberta says she's, trying to mitigate for her clients. What about a take back clause? This is kind of an interesting one when we read these leases where that's a red flag that I pump the brakes and say, hey, there's a take back clause in your lease. If you suggest that you want to assign the lease to someone, to your landlord, and bring a tenant to the table, say, I would like to assign the lease to this quote unquote qualified buyer, and they say, no, they're not up to my standards, can the landlord choose to terminate the lease?
If there's a take back or what I call a recapture clause, yes. And that's something else in an assignment clause that I look for, where effectively, like you said, somebody says, hey, I want to sign my lease. I'm being offered $300,000. This is great. I want to get out. And landlord says, thank you very much for your request for assignment. I'm terminating the lease. Here's your 30 days notice. Now, I always take that out.
Why do landlords have it in there to begin with?
It's kind of the same thing as I was saying for tenants, right? Or for clients. The more options that you have, I think the better you can serve your business. So let's say landlord says, well, you want to assign this lease, but this lease is actually under market. And I know I can do better if I put this on the market. So I'm taking this lease back. Or the other thing that I've unsuccessfully many times not tried to negotiate is if you want to recapture, you cannot do a deal with the person we're bringing to the table, right? Because that person's giving $300,000. So what's to stop landlord to say, okay, let's go, example I gave earlier, Restaurant One LLC, let me terminate the lease. Hey, ABC LLC, if you give me $100K, I'll give you this new lease. So I always try to push back on a recapture provision. I don't think that it's a benefit to the tenant. What is often the middle ground, and I don't like this middle ground, is to say, okay, if the landlord goes to recapture it, then the tenant can withdraw the assignment request. So effectively, it's I want to sign my lease. I'm terminating. Okay, landlord says I'm terminating the lease. And then tenant says, well, I withdraw the request for assignment.
So you've mitigated the situation as a whole if you get that phrase in there, right?
I think you've mitigated it, but I still don't think it's ideal.
Yeah.
But I do want to say one thing about leases. And I tell my clients this. You have to take a lease as a whole. In almost every negotiation, a client will say, these 20 things are deal breakers, right? And invariably, 10 of those things end up in the lease because we got the other 10 out, right? And you have to look at the lease in its entirety to say, is this a good lease? I do think that there are provisions that are deal breakers, but there are times that, hey, if you get a limited guarantee, if the guarantor is off of the lease in an assignment, if there's no transfer premium, okay. Are we going to do a recapture provision where the tenant can withdraw the assignment? Is that then a good deal? Maybe.
Mm-hmm. Interesting. I'm going to try to word this so you don't think I'm asking for legal advice. So going back to these clauses, if I'm going through a lease, Patrick's going through a lease, and we see a recapture clause, we see a shared consideration clause, and those are the things we are immediately going to red flag for our sellers that this might be a hindrance or impede us from actually successfully getting this transaction done. If I say go back to Mr. and Mrs. Landlord and say, are you going to enforce this, or was this almost like boilerplate language that's been in your lease? Like maybe some of these landlords don't even know it's there. They don't enforce it, but it's there. How can we mitigate that with our sellers? Can they go back and say, Mr. and Mrs. Landlord, can you write an email saying you're not going to enforce clause 23.4 recapture? Will that hold up in a disagreement or court?
I don't think you're asking for legal advice.
I did it.
Yes. Look, I think going back to a landlord and saying, look, I want to sign my lease. I want to find you a good tenant. I need to get out. I've been a good tenant to you. Hopefully you could make that statement. And, saying to them, there's this provision in here. I want to know that you're not going to enforce it. Realistically, an email, I don't think an email, it's not an addendum to the lease. Ideally you would get a written kind of addendum, just quick and dirty, so to speak. Landlord agrees to not enforce this provision for, this particular transaction. But most people know their landlords. Is the landlord difficult? Is the landlord great? Is the landlord kind of absent and doesn't even really realize this is in the lease? Most people have a sense of who their landlord is and whether or not they can approach them. But I think if you're bringing a really good tenant, and if that's your goal, and, the landlord might just say, yeah, go for it.
That is our goal. And of course, we don't ever want anybody to roll the dice or put themselves at risk without having clarity on these really big, these impactful phrases or clauses in a lease. So that's really fruitful stuff.
Yeah, that's a whole episode in itself right there.
Yeah, absolutely. Can I hit her with a bonus question, Patrick, or not?
Yeah, please.
All right. This is great.
Andy's favorite question.
I'm scared.
It's my favorite question because it's totally backfired on me about 60% of the time, because most people are loving what they do and they stay within their niche. So let me not ruin it. Roberta, what would you do if you did have to work every day, but you didn't need the money at all? You could choose any path you wanted, any niche, anything you want to do that really fulfills your heart and mind. And what would that be?
So many things.
Okay. A Renaissance woman.
There really are. I mean, there's so many things to do, right? I still think I would do what I'm doing now in part. And I think that I would probably do a couple of things that maybe I wouldn't necessarily be able to do right now. I would say one of the things that I would like to do is be a little bit more proactive in terms of some of the city issues that restaurants face.
Yeah.
Love it. Yes.
If I won the lottery and, I would love to be able to work on those kinds of things, because I think it's so critical, whether it's dealing with the health department or dealing with certain regulations.
Yeah.
Not actually of interest to me, but that, and I think I would also take a souffle class if I'm
Nice. Okay. Well, two things on that then. If you want to buy a restaurant and open up a souffle shop, you call us. You know that. I totally appreciate what you said about that. And frankly, I want to bookmark that because we may call you again in the future. Restaurateurs deal with so many city regulation issues on top of all of the hurdles they deal with day to day and everything else. So that's an interesting topic. So thank you for planting that seed. We greatly thank you for joining us on our episode today. You are a wealth of knowledge. You're amazing at what you do. We look forward to working with you and crossing paths a lot and referring you a lot. So people listening, if you want to reach Roberta, don't hesitate also to reach out to Patrick and I, and we can share her email or whatever with you so you can reach out. She's an invaluable resource. Many thanks to you, Roberta.
No, thank you. You guys are great to work with. I really enjoy it. And I will say this, you guys are always putting your clients first, which is really important to me when I work with a broker.
Many thanks for that. That's really nice of you.
Thank you very much. Thank you.
All right. So, guys, you got to tune in. Over the next month here, we got Jordan Cressman of Sharky's Restaurant Group coming on at the end of the month. We got another exciting podcast we're going to record with a great guest that'll hopefully bring as much knowledge and insights as Roberta did today. So thank you so much for joining. We look forward to you listening next time.
If you enjoyed today's show and don't want to worry about missing an episode, you can follow the show wherever you listen to your podcasts. And if you found today's episode interesting or useful, please share it with someone you think would benefit and consider leaving a rating and review.
Reviews help restaurant owners or buyers just like you discover this podcast and benefit from the important topics covered in the episodes. Your opinion matters to us as a listener, so feel free to leave topic suggestions and feedback for us, as we will use these to tailor the episodes to you and help you get the most out of listening.
Thank you all for listening to this week's episode of Restaurant Deal Making Exposed. If you're considering selling your business and would like a free consultation, reach out to Patrick and Andy at therestaurantsalesbroker.com or visit www.therestaurantsalesbroker.com to learn more.